submission and appeal in the matter of the Claimant application of JIMSSET.
My Lords, good morning. I appear for the respondent. My learned friend Mr. Dan appears for the appellant.
Yes.
The first order of business today in my submission is the application by the respondent to produce the transcript of the hearing before Mr. Justice Linden.
Yes. Do you need to apply? I thought one could.
It's disputed. I'm afraid it's not accepted by my learned friend, so I've made a formal application because of that. In my submission, there can't really be very much to oppose. It is, of course, entirely regrettable that the tape did not pick up everything that was said. But there are times, as your lordships will know, where unfortunately we have to make the best of the job that we have in front of us. And I do say that there are certain things in that transcript which I do need to draw to your lordship's attention. And therefore I do seek permission to adduce it.
Yes. Mr. Dunn.
Well, ordinarily there would obviously be no dispute. A transcript would be helpful to your lordships and your ladyship. The question really was about the utility of the transcript, because it isn't just the normal case that the transcript has a few missing words here and there. The transcript, in actual fact, misses almost everything that the appellant says. Now, if it's of use or will be of use to your lordships and your ladyship, there's no objection. It was just to make that point that this is a transcript where, and I have been through the transcript, and it seems from my reading of it that almost everything that Mr. Emezi says is just not picked up at all. So it doesn't contain his submissions. Now, that's really the start and end of the issue. If the court would find it helpful, then I don't object to it going in. But it may have limited utility where there is one party's submissions are just not recorded at all. But I'm in the hands of the court. I don't make any submissions other than that. It just by way of example, if one just takes the first page of the transcript, so page 2, one can see that Mr. Joseph and Mr. Justice Linden, their words are recorded. In fact, some of Mr. Joseph's words, my learned friend's words later on are inaudible, but as one goes through those first few pages, page 5 for example, one can see that the entirety of the responses to the judge are missing.
You're talking about a document which certainly I don't have, my lady doesn't have.
I've got unagreed bundle. I've got it in electronic form.
Unagreed bundle?
Yes,
I didn't have an unagreed bundle in electronic form either.
No.
Or if it assists, it was appended to the application itself. I do have an unmarked copy, but only one, I'm afraid. Well, we have between us. We do have.
Embarrassed to say, I don't have it at all. Usually, it's not jury proceedings. Usually, if somebody has made a transcript, even an incomplete one, of part of the proceedings, and one side asks us to look at it, we'll look at it. You might say it's irrelevant. You might say there's so much missing that it's of no value. Fine, but it's a rather extreme step to say that one can't look at it at all.
I don't take that extreme stance.
All right. Well, shall we have it then?
Thank you very much.
Thank you very much. Right, well then, back to the normal order of things, and to you, Mr.
I'm grateful. So it is my appeal, and it's admittedly a discrete point, and it often comes down to discrete points that this court has to deal with. But it is, for reasons I hope I will make clear, it's an important point, because the question before the court today is, if a judge hears a hearing or an application and then makes a costs order, are they permitted to remit that for a summary assessment to a cost judge? And the appellant says, no, they're not. And the appellant says that it's clear from the rules that they're not. But it may be at the forefront of the court's mind as to why this even matters. What's the problem with it? And I hope to very briefly deal with why it is not appropriate for cost judges to deal with matters on a summary assessment where they haven't been involved in the case thus far. And
Before you do that, I'm sorry to interrupt. The issue about cost officer, cost judge is no longer live. Is that right?
that's right.
Thank you. I just wanted to make sure.
And that's because the rules essentially say cost officer includes cost judge. Or
Yeah.
cost
And the order itself said
officer, a master.
a master.
It did, yes. And in fact, it has been sent to the senior cost judge. And I should say, at no point of these submissions will I make any arguments that cost judges are somehow incompetent or unable to. They are absolute experts in the field of costs, and they command the greatest of respect, certainly from my learned friend and I, who are members of the cost bar. They are not permitted to hear summary assessments, not because of the difficulties of doing so, but because the rules, it's baked into the rules, that the person who undertakes a summary assessment, which is a summary process, has to be a judge who has knowledge, understanding and background of the case itself. And that's why the rules, we say, are written as they are. Now, a judge at the end of a busy day's hearing is not under any compulsion to summarily assess costs there and then. The rules give a judge essentially three options. If there's time, they can undertake a summary assessment. If there's not time, they can adjourn the assessment and have it relisted before them at a later date, by telephone or by Teams, if that's more convenient. Or the third option...
Or on paper.
Or on paper, indeed,
Yes.
yes, or on paper, and that often happens, for example, in this court, that often happens. Or there's the third option, which is they can remit the matter to a cost judge. But the judge can only send it to the costs office for a detailed assessment. What they can't do is send it for a summary assessment. So the principle, I say, is simple. If a summary assessment is to be undertaken, it's the judge who heard the hearing or the application. If the judge who hears the hearing or application, either because of time or because of complexities, for example, within the cost schedule or issues that have arisen, if he or she takes the view that it should go to the cost office, there's no problem with that, but it needs to go for a detailed assessment. That's really the issue and the starting point.
Do you also say, those are the three options, second of which was adjourned for relisting before that judge. Do you also say that it's impermissible for one High Court judge to adjourn it to be heard for summary assessment by another High Court judge?
Well, for the purpose of this appeal, I don't need to go that far.
I understand that.
But I do say yes, that is the effect of the rules.
The summary assessment has to be done by the judge who conducted the hearing.
Yes, I do say that. And what I'll come on to, and obviously what is argued in my learned friend's favour from the respondent's position, is the judgment of Lord Justice Coulson, or Mr. Justice Coulson, as was in the Transformers case. And I'll seek to distinguish that from the principle that I'm bringing here. The only caveat, after I've just said this is a simple matter, I probably shouldn't raise caveats, but the only caveat potentially is if there has been no hearings or applications at all. So if everything has been done on the papers, for example, it may be that in those very limited circumstances that there isn't there isn't any issue with a separate judge undertaking a summary assessment. And that's really the point that was
Transformers.
dealt with in the Transformers
Yes.
case. But that is different, certainly different from this appeal because it goes to a cost judge, but certainly different from the general position, which is can one High Court judge, for example, have another High Court judge undertake a summary assessment when Judge A has heard the hearing or application.
I'm sure you'll fit it in logically to your
Yes.
submissions, but as the rules stand, I would have thought that your base position was that's not possible either.
It is. It isn't possible on the basis of the rules. I mean, it's certainly not possible once there's been a hearing or application in my submission.
No, but if it's been on the papers.
On the papers, the rules suggest that it isn't possible. I mean,
Yeah.
In my submission, the problem for the respondent is that one would have to bring that into sort of general case management powers, discretionary powers. But the rules are absolutely clear about what should happen and which judge should undertake a summary assessment.
The beginning and end of your case is the definition of summary assessment in CPR Part 44.
It is, yes, and really, if one reads the rule at 44.6, it makes it absolutely clear that judges have a choice, but they only have a choice in respect of detailed assessment in terms of sending it on to a cost judge. And I'll take your lordship's, your ladyship through the rules very briefly.
I think you're entitled to say in the written application type of case considered Transformers, it may be very sensible that the rules should provide the option of sending it for summary assessment by a cost judge, but they don't.
Well, that is ultimately my submission, because I would accept that the problems that arise with the idea of a separate judge summarily assessing don't arise where there has just been matters dealt with on the papers. So the mischief that it's meant to cure doesn't arrive, and I would accept that. But until and unless the rules are amended, that is ultimately what should happen in my submission.
Well, before we look at the rules, was this point made to the judge that you can't do this?
Well, my understanding from instructions was that it was dealt with at the end of the hearing, and it was dealt with as a fait accompli. I obviously haven't seen the transcript. From my understanding, and my learned friend was there were not submissions as I'm about to make before the judge, and I fully accept that.
My lord, I can assist the court with that. This is why I wanted the transcript in, because at the start of the hearing, the learned judge asked both advocates, myself and Mr. Amesier, what are the issues that I have to decide? Because your lordships will have seen that there was a Part 36 offer in relation to a discrete part of the appeal, which was the costs of the detailed assessment, which had been accepted. So that had been, we thought had been sorted out, but his lordship needed to confirm that. And he then said, well, what are the issues? And in the transcript, if I could ask your lordships please to look at this, the page that I would invite you to look at first is page 4, top of page 4, please. Your lordships will see it at A. The learned judge says, yes, Mr. Amesier, can I just ask you, what are the issues then on the draft order? Because I produced a draft order which requested a summary assessment before Master Brown, the master who had dealt with the detailed assessment, and directions for that to take place. This was my draft order.
I'm sorry, could you repeat that again? What kind of assessment before Master Brown?
A summary assessment by Master Brown, specifically by Master Brown. I had my draft order reflected that, my lady, the draft order is in the bundle somewhere, but it is clear that I thought about this before the hearing. I had produced a draft order, and I said, let's have a summary assessment for Master Brown in the Senior Courts Cost Office. And your Lordships will see at the top of page 4 that the learned judge says, can I just ask you what are the issues then on the draft order? Is this right, that you dispute that he should pay the cost of the appeal, other than in other words, you dispute should pay the costs of parts of the appeal that were abandoned on the 9th of December? So you can see his lordship starting there to ascertain what the issues were. Further down the page at G, he's still talking to Mr. Amizier. At the moment, I would just like to know what the issues are. And he talks again about paragraphs 1 to 3 and paragraph 4. The next page, at the top A, the learned judge, right, then it is also disputed that the matter should be sent for a summary assessment, is it, by the master? Then he says this, but if we look at the order, would you mind looking at the order? I understand there's an issue about paragraph 4. Then what is said is precisely as you have just indicated, that the costs would then go for a summary assessment by a master and directions are given to achieve that. Do you object to that? You do not object to that, right? And then he says this, I see, so the issue is not Master Brown. Now, what that indicates in my submission very clearly is that at the hearing, it was not ultimately contested by the appellant that there should be a summary assessment by a master of the Senior Courts Cost Office. The issue was whether it should be Master Brown. And ultimately, the learned judge decided that he would just simply direct that it should be a master and not Master Brown. And your lordships may have seen from other papers.
We've seen the,
yes.
The
and
actual
I said
judge.
I wasn't going to the scaffold was the phrase that I used on it. I said I put forward Master Brown, but I'm not going to the scaffold on that. So at the hearing, the only issue for the learned judge in this context to decide was whether it should be Master Brown. He was not asked to consider in any detail at all whether there should be a detailed assessment as opposed to a summary assessment. And if your lordships look at the approved judgment, which is at page 28. Sorry.
Mr. Jones, probably better not let
Yes.
you argue the case at the moment.
I'm sorry.
You've drawn our attention to relevant parts of the transcript of
Yes.
the submissions. We've got the judgment. It looks as though it's pretty clear that nobody took the point. You were, assuming that Mr. Dunn is right, that the CPR 44 does not give power for this to be done, you were putting forward a draft order which asked for something which the court has no power to do. Mr. Amazier didn't object to it, and the judge didn't notice it either. So everybody was proceeding on the basis that the court had power to do this, and the question is whether it should be reserved to Master Brown or not.
Nearly, my lord. I do say that the court does have power.
Yes. All right.
So, in other words, just to be clear, I was not deliberately putting forward.
And something for which there was no basis.
Let's be clear about that.
Yes.
I was putting forward, because I drafted the order, let's be clear about
Yes.
that. I drafted the order. I was putting forward what I hoped was going to be a sensible solution to the problem that was then live, and no doubt you'll hear from me a bit later, and I'm sorry that I've troubled your lordships a bit too much on this, but I hope that's of some help. That's
Thank you
what
very
happened.
much.
Thank you.
So, in terms of how subject to anything your lordships or your ladyship wishes to hear from me in respect of, my proposal in terms of my submissions is to firstly deal briefly with why it's important, which explains, I say, why the rules are as they are, and then look at the rules in relation to remitting to a cost judge, and then deal with the wider point, which is the transformers point of whether one judge in the High Court can ask another judge in the High Court.
Yes.
So, as I said at the outset, it's nothing to do with whether cost judges are able to conduct summary assessments. In fact, cost judges at the end of detailed assessments conduct summary assessments all the time. It's a regular part of the exercise of detailed assessment. But of course they do so having heard the evidence and made the order. So they do so within the confines of what I say the rules are. What they don't do in my submission, what they don't have power to do, is summarily assess costs made by of orders made by other judges. They don't do that for good reason. The question is not at all about the hierarchy of judges or whether a master should have the power to do so. It's really about what's proportionate and fair and just. And ultimately, the clue is in the name in these processes, summary and detailed. And it would produce, I say, it would produce unjust results for a judge who has had no involvement in a case at all, no involvement or consideration of any of the issues, conducting a summary assessment of the costs. Firstly, because summary assessment costs don't need to be modest. This court, for example, sees summary assessment schedules which are for very large amounts, and as does the High Court. So they can involve complex issues, they can involve a great deal of costs. And what a summary assessment is a rough and ready, if I can use that phrase, approximation of what reasonable and proportionate costs are by the judge who has heard the matter and understands the issues. So the judge will have the very limited summary assessment form, which spans 4 pages. There's no detail at all in that form other than for documents timed.
This is the N260.
At the N260, my lord, yes. There's no actual requirement even to use an N260, so as long as it reflects what the N260 says. There's obviously no...
There is a requirement, if you're going to ask for summary assessment, to file schedules of costs, exchange them at least 24 hours before the hearing.
That's right, yes.
That wasn't something that happened in this case.
No, well, it did, but the problem was that the judge made an order which limited the parties' costs in terms of periods of time.
And it wasn't broken down in that way?
Yes. So there wasn't an ability to summarily assess the costs.
Yes, thank you.
My lord.
And that's what the judge says in his judgment.
Yes. And there's no criticism of the judge for finding that he couldn't summarily assess the cost there and then. In fact, it would have been tantamount to impossible to do so. But the question is what he should have done thereafter.
Yep.
But on a summary assessment, so there's no narrative at all. So there's no explanation of what's happened in the case on a N260. There's very basic details. Judges, obviously, if they have come to the matter afresh, won't have the file of papers, etc. And it is a summary process. It is designed not to go through each line item by item or hear arguments. Ordinarily, without wishing to give evidence, but the experience of the bench is far greater than mine. But ordinarily, one hears brief submissions from the parties on what the issues are, and then a decision is reached. And to contrast that with detailed assessment is really highlighting the reasons for the two regimes, because the detailed assessment is for a judge who has had no involvement whatsoever with the case at all until the point that there is an assessment. And that judge, he or she will have a full bill of costs, or an e-bill, which can be filtered, will have the full file of papers of this claimant's solicitors and undertake pre-reading before the detailed assessment. We'll have, in most cases, we'll have pleadings in terms of points of dispute, always points of dispute, and ordinarily one would have points of replies. And they would take each item and put objections and responses. But there would be also preliminary issues dealt with in those pleadings, those cost pleadings that the judge would read. So the cost judge sitting down to a detailed assessment has all of this information before them and is able to come to an informed decision as to what reasonable and proportionate costs are. But what they cannot possibly do that in my submission if it is a summary assessment and they've had no prior involvement. And it is telling, I say, that in this case, for example, there was a requirement for a transcript at public expense because it was recognised
Of the whole proceedings.
because it was recognised that a cost judge would be in no position to properly deal with those issues. So, for example, just your standard run-of-the-mill arguments on detailed assessment, things like whether a particular fee earner should have been used, should it have been an A or a B, whether the guideline hourly rate should be used, or whether there should be an enhancement, if so, what, proportionality. All these routine matters are appropriate for a cost judge on detailed assessment to consider because they have all the background, but not on a summary assessment. It would be tantamount to impossible for a cost judge to undertake that task. And it would also, I submit, and again, this is the sort of wider issue, it would be impossible fairly for a judge, for example, for another High Court judge to undertake that task. Because what one is getting with a summary assessment is, as I say, a rough and ready, broad brush, broad approximation of what reasonable and proportionate costs are. And that, if that task is undertaken by a judge with no prior knowledge of the matter and not enough information, it will lead to injustice. And injustice potentially for either side. Too much in terms of cost, too little in terms of cost. So that's why I say the rules are as they are, and they are in my submission absolutely clear. They could not be any clearer in my submission. So if the starting point, if I could ask in the authorities bundle at page 113. Is 44.6. Now, the respondent...
Well, it isn't the starting point at 44.1.
Well, yes, it is. And I was going to do it in the other order, but no, my lord, you are, of course, quite right. 44.1, so that's on page 101 of the bundle. And that sets out clearly what a summary assessment means.
And also what a detailed assessment means.
Indeed, yes, my lady. It compares and contrasts the two, because of course the cost rules are as they follow 44 to 47 set out the procedure for both. But in fact, if one looks at the detailed assessment at page 100 definition, it says detailed assessment means the procedure by which the amount of cost is decided by a cost officer in accordance with Part 47. So that's detailed assessment on the one hand. At page 101, summary assessment means the procedure whereby costs are assessed by the judge who has heard the case or application. And as I say, it couldn't be clearer. In fact, this is not a rule which is ambiguous or where one has to read anything into. It is absolutely clear on its face.
And costs officer means a cost judge, district judge, or authorised officer.
Yes, it does. Yes, that's right.
I'm quite unfamiliar with what officers, as opposed to cost judges, can do. What happens in practice?
Well, in the senior courts costs office, the cost officers who are civil servants rather than judicial officers assess costs below a certain level. So they will assess under the provisional assessment level, but I might need to be corrected on that.
It's from memory, I think it's about £50,000. There are cost officers who, as my own friend says, are civil servants, and they will do the smaller bills. They have the power to refer it to a cost judge if they feel it's appropriate. Could I just also mention in this context there's the provisional assessment process for bills that are up to £75,000, because I do take a little issue with what my learned friend said about the documents that a cost judge will get on a detailed assessment. The provisional assessment process is set out in 4715, and it is for bills that are put at up to £75,000. They are provisionally assessed on paper by usually by a cost judge. It can be a deputy as well. And if the parties don't like the decision that's made, they have the option of asking for an oral review of the bits of the decisions they don't like. But the practice direction to Part 47 limits the documents which the learned judge will see on a provisional assessment. It is at paragraph 14 of the practice direction to 47, which is at page 1691 of the current edition of the White Book. I don't want to hijack my learned friend again, but that paragraph does limit the documents which the court will see on the provisional assessment. And it's only if the matter goes to a detailed assessment with a full hearing that further documents might be lodged. I just respectfully draw that to your lordship's
All right.
attention.
Well, for present purpose, it's actually quite useful, speaking for myself, to have evidence from the two of you who know more about what actually goes on than I do. But for present purposes, does it come to this, that there, at any rate, up to a certain level of costs, if an order for detailed assessment is made, what may well happen is that there is a provisional assessment on the papers, and then only if there's a row about that, or the bill of costs is so big that it's above the 75,000 cut-off, that it would go to a hearing before a cost.
Yes, then there's the capacity to go to an oral review before the same judge. But the provisional assessment is important, because if one contrasts provisional assessment with a summary assessment, if a cost judge on a provisional assessment has limited papers, etc., or makes a decision which aggrieves one of the parties, then there's no appeal needed. One can apply for an oral review, and so that is quite different from a summary assessment, where obviously once the summary assessment is done and dealt with, unless there is an appealable point on a summary assessment, that's the end of it. So I would say that the provisional assessment process doesn't assist in the sense that doesn't assist the respondent in the sense that it doesn't deal with what the rules say, but also it is a specific, proportionate way of dealing with lower value bills. But it includes explicitly the protection for the parties in the oral review stage, which that protection is lost in the summary assessment stage if there is a judge assessing who doesn't have the background knowledge. And so coming to 44.6, page 113 of the authority. This really, I say, the definition makes it clear in my submission that this is not permissible. But what is argued by the respondent is that the words at 44.6 are discretionary, not mandatory. And so the respondent says that 44.6, when read, actually gives a judge the discretion to send for a summary assessment before a cost judge. But in my submission, that simply can't be right.
I understood that the discretion was suggested to arise in the practice direction rather than in the rule itself.
Well,
But
yes, my lady, at paragraph 13 of the respondent's skeleton argument, it says CPR part 44.6 is by use of the word may, discretionary, not mandatory.
okay, sorry.
Yeah, as I understand it, and obviously I won't make my learned friend's points for him, they say both. But 44.6 is actually very straightforward and simple. All it's saying is, it says when the court orders a party to pay costs to another party, it may either. And so the use of may there is not to say it's discretionary, it's just to say you've got a choice. It may either do this or that. And it may make a summary assessment of the costs, and note, make a summary assessment, not order. So the court's making the summary assessment. Or order detailed assessment of the costs by a cost officer, i.e. a cost judge. So it's absolutely plain in my submission that the only part of that rule which allows for a detailed assessment is that the court can order detailed assessment by a cost judge. But if it's a summary assessment, of course, the court has to make the summary assessment. In other words, the judge undertakes the summary assessment.
But he doesn't have to do it straight away.
No.
He can adjourn it to himself a week's time.
Of course, yes. No, there's nothing objectionable about that at all. In fact, that would have to be the case because of the pressures of the judiciary. No one is suggesting, certainly on this side of the court, that 5:15, a judge has to sit down and undertake a summary assessment of costs. If there isn't time, then it can be adjourned, and as my Lord Justice Bean says, either on the papers or by video or another hearing.
And not only if there isn't time, but if, as happened in this case,
Indeed.
the N260 doesn't break it down in the way necessary to give effect to a judge's order, it can't be done.
No.
There and then.
And that's not an unusual situation, because if a judge is making orders which are split orders or percentage orders, it's not unusual for that that he or she will require new N260s to come in. So there's no objection to that.
And at that stage, in this case, the schedules of costs being of no assistance that he'd got, he had the choice, which is in 44.6, to make a summary assessment at a later date, or to send it for detail.
Yes, and those are the choices. But the summary assessment of costs is for the court to make, or they can order it goes somewhere else to a cost officer. I mean, in the rules, detailed assessments by a cost officer is only mentioned in the context of detailed assessment, which obviously complies completely with the definition of what summary and detailed assessment is in the rule. So there's nothing unusual about that. And then the practice direction sets out, and the practice direction is to be found in the authorities bundle. At 95. Which is at 9.7 of the practice direction. So 95 of the authority bundle. And here, the practice direction is doing precisely what practice directions are supposed to do. They're providing the point that my Lord Justice Nugee makes, that it doesn't have to be done there and then. So that's the first point. There is a choice in terms of when it's undertaken, but there isn't a choice in terms of sending it off, and that's, one can see that by the headline, no summary assessment by a cost officer.
And what's the status of this paragraph?
Well, I fully accept that if this paragraph, as a practice direction, if it was in contrast with the rules, or it sought to provide or promote a point of law which was unlawful or wrong, then it could be ignored or be considered irrelevant. But when one analyses 9.7 of the practice direction with the definition of summary assessment and the rule at 44.6, it is clearly giving effect to the rule. And all it is doing is making the point that a summary assessment can be conducted at a later time. So this isn't a case, I say, where the practice direction is in conflict at all. In fact, if the practice direction said what the respondents now argue for, then it would be in clear conflict with the rule, in my submission.
Is there anything in the CPR about what practice directions are, and what effect is to be given to them?
There is, in the authorities bundle, there's the decision in Lee and Michelin Tyres, which deals with practice directions, which is cited in my
Yes. I just wonder if there's anything in the CPR itself. The CPR obviously contemplates practice directions, because it quite frequently says, unless these rules or a practice direction says otherwise, blah, blah, blah. But is there anything which says the court may make practice directions to supplement the rules or anything like that?
It was the Civil Procedure Act, the 1997, which provided that practice directions can be made by statutory instruments, but they don't go through the process of the rules themselves.
Are they statutory instruments? I thought they were issued by the Lord Chief Justice or
Yes.
whatever. Are they statutory instruments?
So, my Lord, at 75, page 75 of the authorities bundle,
Yeah.
the Lee and Michelin Tyres case. And it's at paragraph 19, there's the quotation from Lady Justice Hale, as was in the Godwin case.
She says practice directions are not made by statutory instruments,
No,
which is rather what I had assumed.
yes, and that is why, my apologies, that is why they are not in the same way as updates to the CPR, which are made by statutory instruments. So they don't have the status of the rules.
They're not made by Parliament or by the executive.
No.
They're made by the judiciary.
Yes.
Yes.
And so I don't take there's no issue between my learned friend and myself that if this court finds that the practice direction is wrong or is not a proper statement of the law, then it can be ignored.
Lord Justice May seems to have said in the quotation, paragraph 20, that practice directions are subordinate to the rules. See paragraph 6 of Schedule 1 to the 1997 Act. Do we know what that says?
That's the Act itself. I don't have a copy of that, but I do accept that they are subordinate to the rules. So if the rules in practice direction are in conflict, then the rules
take priority.
win out every time.
And the rules are made by statutory instruments,
Yes,
so
they are.
they're a form of delegated legislation.
That's right. Yes.
Yeah.
So they are. So as my submission is, if I was seeking to persuade this court that the practice direction somehow overruled the rules or made law which was not envisaged by the rules, then that would put the appellant in a difficulty. But it doesn't, because if one looks at the definition and then looks at 44.6, and 44.6 explicitly allows only detailed assessment by cost officers, then the practice direction is giving effect to those rules. And in those circumstances, I say that there isn't the issue that can arise with practice directions versus the rules. The rules will always win, I would say.
Well, all that paragraph 6 of Schedule 1 says is civil procedure rules may, instead of providing for any matter, refer to provision made or to be made about that matter by directions, which doesn't help very much.
No.
In the judgment of Lady Justice Hale cited in Linden Michelin Tires from 2001, it refers to the need for practice directions to be approved by the Lord Chancellor. Does anyone know whether that is still the case post-Constitutional Reform Act?
If I can weigh into this such
Yes.
as I can, my understanding is that the Rules Committee makes practice directions. They're then formulated into a statutory instrument, which is signed off, if that's the right word to use, by the Lord Chancellor, because he's got authority under some statute. You'll forgive me if I've not got the foggiest as to which one it is, that he's got power to do that. I think that's the process. And the Rules Committee, of course, is populated not just by judges, but by other practitioners.
Yeah, we know that.
Yeah,
But anyway, there is still sign-off required, not only for rules, but for practice directions.
I think that's the case. That's off the top of my head, if I may say so.
That's
my
not
understanding.
not quite what Lady Justice Hale says she suggests. But it's the court that makes the practice directions. And that they can be approved by the Lord Chancellor, but they're not statutory instruments. It may not matter, because I don't know that there's any difference between you.
No.
No.
Practice directions can't override the rules, but they can fill in gaps in the rules. So
Yes.
Yes.
you can point to practice directions if they're consistent with the rules, but if they're inconsistent with the rules, they're of no effect.
The court can ignore them. Yes,
Yes.
indeed. And the Linden Michelin Tires case sets that out. It says that practice directions, and this at paragraph 21, are made pursuant to the power in the court to regulate its own procedure within the limits set by the statutory rules and to fill in gaps left by those rules. Now, it may well be that the practice direction at 9.7, the point of it is to ensure that a judge has the ability to undertake the summary assessment at a later date. So it's filling in that gap and ensuring that the power of the judge to do that is set out in that practice direction, which is explicitly what the practice direction says. Because it allows the court to give directions as to a further hearing before the same judge. So that's why the practice direction is there.
But you rely on the first sentence, which says you can't order summary assessment by a costs officer, and that includes a costs judge. Therefore, you have a clear statement in the practice direction that you cannot order summary assessment by a cost judge.
Yes, you have a clear statement in the practice direction which supports and is in line with 44.6 and in line with the definitions. So my submission is there's no conflict between any of these. You can read them all together and they all support the same point.
Nothing is going to turn on this, I think, but the statute governing practice directions, Civil Procedure Act 1997, Section 5, and it appears that they always need the approval of the Lord Chancellor or the Lord Chief Justice, sometimes both, sometimes one but not the other. But anyway, need not go further into that.
So those are my submissions on the question of whether the cost judge, unless my lords and my lady have any points that they wish me to go through further in respect to the cost judge. So I say that there isn't that ability, and it's understandable in my submission why. The wider question, and this is the Transformers case, is whether one could, Judge A can remit for Judge B to hear the summary assessment. So two judges of the King's Bench Division can they do so? And of course that isn't a question for appeal, but it's an important question in my submission. So the Transformers case, which is at the start of the authorities bundle, is used and relied upon to support this proposition that Judge A can ask Judge B in the same division to undertake a summary assessment. But it is an obviously distinguishable case, and it is, in my respectful submission, wrong in any event, because what it doesn't do is take into account the full meaning and wording of the practice direction. But as a starting point, it's a case where Mr. Justice Edward Stewart had made 2 orders on the papers, and then Mr. Justice Coulson had heard a hearing and was asked the question, can he summarily assess all 3 cost orders? Well, obviously no issue with the costs of the matter that he'd heard. The question was, what about the other 2 that had been done on the papers? And his conclusion was that he could do. He could summarily assess those, even though he hadn't made the orders. And that was really for 2 reasons. I mean, it's right to say that a significant part of the judge's reasons was that there hadn't been hearings of the other 2 matters. And so, page 4, paragraph 11 of Transformers, the judge makes the point that his view is particularly the case where there are orders made on the papers and not at a hearing.
He doesn't seem to have been referred, or at any rate he doesn't cite, the definitions of summary and detailed assessment.
No, he isn't. No, my lord is absolutely right. There's no consideration of the definitions or indeed of the wording of 44.6 and how that sets out cost judges' detailed assessment. But also the wording of the definition makes it plain in my submission that this is not correct in its analysis.
And his analysis turns at 9 on May in
Yes.
the practice direction, which he gives quite a wide ambit.
Yes.
And then the overriding objective. So that's 9 and 10, isn't it?
Yes, that's right.
And he distinguishes Mahmood on the basis that they were older versions.
Yes, and this is really the second of the main reasons for the judgment. So, if one looks at the Mahmood case, which is on page 9 of the authorities bundle, the section I wish to take the court to, if one can see that in Mahmood, at paragraphs 11 and 12, there was a different practice direction, and what Justice Coulson said was that practice direction included the word must, and this practice direction, as is now, includes the word may. But I mean, as I will come to in brief, that is not a conclusion which I say can withstand scrutiny. It's worth noting in my submission what is said at paragraph 12 of Mahmood,
Which is that Sir Swinton Thomas construed the whole sentence. And so he didn't hang his hat on must, he hung his hat on a further hearing before the same judge.
indeed, and now those are said to be the important words.
And they're the same words.
Yes, so those haven't changed, and they are the important words because it's difficult to see how an analysis of the difference in may and must can lead the judge to the conclusion that is reached in Transformers without considering the final part of the practice direction. And there is no consideration in Transformers of what that final part means before the same judge.
Do you have a submission as to why the wording was changed from must to may and what the effect of it is?
Yes, so in terms of why it says may, if I can just bring up the practice direction again. it says may because it's reflective of the choice that the judge has. So if the court is unable to do so on the day, the court may give directions as to a further hearing before the same judge. Now that is a proper reflection of what the rules say, because there is the other option, which is to remit the matter for a detailed assessment by a cost judge.
But it's a little bit odd because the sentence starts in both iterations. If a summary assessment of costs is appropriate,
Yes.
but you can't do it on the day. So you've already made the decision, but in principle, summary assessment's appropriate. You can see why the first version of the practice direction says, well, in those cases, what you have to do is adjourn it to yourself and give directions. It's a bit odd now. You have a discretion. You've decided summary assessment's appropriate. You may give directions for it to be adjourned to yourself, but you may, and you say, actually decide to send it off for detailed assessment, even though you've decided summary assessment's appropriate.
If summary assessment is appropriate, but there's not time or sufficient information, then the court has the choice, and the court has that choice. Now, it might be that it is at first glance suitable for summary assessment, but for example, the judge may be about to embark on a 9-month trial.
Yeah.
In which case there has to be the because this is what the rules state, that there is this choice, summary assessment or detailed assessment by a cost judge. There has to be a reflection, I say, of the fact that there is another choice here, which is why the may is put there. But even leaving that aside, what Transformers doesn't deal with is, as I say, the final line, because there would be no reason or rationale for the new version of this to include as to a further hearing before the same judge if it wasn't intended to reflect the rules which say that very point. They would have changed, it would have been changed, obviously, on that basis.
Practice direction, paragraph 9.7.
Yes.
Is identically worded to the paragraph of the practice direction considered in Mahmood, except that must has been changed to may.
Yes.
Give directions as to a further hearing. My guess, but by all means you, Mr. Joseph, can submit that I'm wrong about it. My guess is that in 1998, whatever it was, obviously remote hearings were unheard of, and it was quite unusual in those days for judges to decide anything on the papers. And so a rule saying the court must give directions for a further hearing would nowadays be considered very old-fashioned. That might be the reason for may, but you say
Yes.
it doesn't alter the fact that the words before the same judge
No.
Are retained.
No, and that is if I may say, an explanation which makes perfect sense, because it would be absurd if a judge who says to the parties, can you send in written submissions as to costs and I'll make the decision on the papers, is then told, well, the practice direction says we must have a further hearing. It would just be absurd.
And I'm going out on circuit to try a murder in
Yes.
Newcastle, and you'll just have to come to Newcastle for
Yes.
this unnecessary hearing.
Yeah. And I'll see you in 9 months. I mean, it would lead to an absurdity in those situations. So I say that Transformers is not on point, but it is on analysis. It is wrong, and it's clear that the judge wasn't taken to the relevant parts of the rules. And so, although the appeal is primarily concerned with the issue of the cost judge, I do say it is impermissible for Judge A to ask Judge B to summarily assess the cost. And the reason for that is all the reasons I set out why it would be unjust for the cost judge to have to undertake a summary assessment can be dealt with in the same way. So those subject to anything court wishes to ask, those are my submissions on the main point, the summary assessment point. My lords, my lady will have seen that there is also part of the appeal, although very much in the alternative, is the matter of the directions given.
Before you get to that,
Yes.
can we go back to Transformers?
Yes.
So you say, number one, Mr. Justice Coulson, as he then was, is wrong about his may and must.
Yes.
Put it that way. What do you say? And therefore, another judge, another High Court judge, can't deal with it, whether it was a hearing on paper, whether it was a hearing or it was dealing with the matter on paper, doesn't matter. Just can't do it.
Yes.
And then, what do you say about his reasoning about, oh, well, the overriding objective helps here? You may want to do that in reply, but I was just trying to wrap it all up.
I'm grateful, my lady. And my submission as to the overriding objective is that obviously one is looking to interpret the rules so as to deal with cases proportionately and justly. And the first point I would make is that if one is going to have Judge B summarily assess costs of a hearing undertaken by Judge A, it is not proportionate at all for a second judge to become involved and have to read into what could have been a very complex trial, for example, or it could have been a complex application. It is adding a layer of complexity and cost, which is not required because Judge A can deal with the matter at an appropriate time in an appropriate way, whether it's on the papers or whether it's on.
Well, that reminds me to ask what I was going to ask soon anyway, which is what order would you like us to make? Are you saying that we should send it back to Mr. Justice Linden and say, you must do the summary assessment? Or are you asking us to say there must be a detailed assessment?
Well, may I turn my back? I'm told that we don't object to a cost judge dealing with the matter, but it should be on a detailed assessment basis. That would be our proposal in terms of the order.
So we would substitute an order for detailed assessment.
Yes.
Whenever the court orders detailed assessment, it ought also to order an interim payment on account unless there's good reason not to.
Yes.
Is there good reason not to in this case?
Well, in terms
if we get to that stage.
Yes, but there would, in terms of payments on account, there are obviously cost orders flowing both ways. So it would certainly be open to either party to seek a payment on account. But what is clear from the case law is that one doesn't have to make that application when the order is made. So if for example, if I were to succeed in this appeal and the order is changed to detailed assessment, the parties can apply to the SCCO for
An interim payment on account.
under 4428. So it doesn't need to be at the time the order is made. It can be done later. And also there are also provisions for interim cost certificates as well in detail.
But that's in the detailed assessment process. But you say that you can apply under the 44.28 after the order for detailed assessment has been made, but before the detailed assessment happens.
Before the
because normally you get 3 months to lodge your bill.
Yes.
Yeah.
Yes, you do. And that obviously commences the detailed assessment proceedings or process.
So you wouldn't expect us to have to grapple with an interim payment application, whatever we do.
No, that wouldn't be my my suggestion, my lord. No.
Can we go back, though,
Yes.
to the overriding objective? Because when I asked you about that, you said it wouldn't be proportionate for Judge A to send it to Judge B, etc. And that's, no doubt you say, is why in this case it's not proportionate, because you had the transcript which was ordered, etc. But what about the, at a higher level, can the overriding objective, pursuant to Rule 1.2, which says read the rules, all of them, in the light of the overriding objective, except a few tiny exceptions. How do you have a submission about whether that is possible when one comes to 44, 1 and 6, etc., and what effect, if any, reading those rules in the light of the overriding objective would have?
Well, thank you, my lady. I would say where the rules are clear and unambiguous, and where they don't obviously lead to unjustness, then there isn't actually much room at all for the overriding objective. The overriding objective is designed to be a prism in my submission through which one reads the rules. But it is only if, as a sort of starting point, that there is ambiguity in the rules, and one interpretation would lead to very disproportionate outcomes, and one would lead to proportionate outcomes. And of course, a court may, in my submission, consider the rules through the prism of the overriding objective. But in this case, the rules are absolutely clear and unambiguous and plain. They're supported by the practice direction. And even if one does take into account the overriding objective, the unjustness of having a judge who hasn't heard the matter undertake a rough and ready assessment, the potential for injustice would be great. And therefore, even if the overriding objective became an important point, it supports, I say, it supports the appellant's argument. It doesn't support the respondent's argument.
Thank you.
I think that was really two answers. One is you can't use the overriding objective to interpret the rules in a way that they can't bear. That's just an interpretation point. And the other is, even if you could, it wouldn't on the facts.
In the time-honoured phrase, your lordship puts it better than that.
No, I'm just trying to understand quite what it is
yes.
you're saying. Yes.
So if I may move on, and I'll deal with the issues as to directions for assessment briefly, if I can. The question here is whether the direction, if I'm wrong about everything that's gone before, and the judge was entitled to make the order he did, was he entitled, or was it outside the generous ambit of his discretion to make the directions that he did in respect of the summary assessment? And I start by accepting that these are, unlike, I say, the issue of summary assessment, these points are case management points, and I fully accept that I would have a high hurdle to get over in terms of seeking to set this aside. What I would submit is that they were unduly and unnecessarily prescriptive, and what one sees with the directions is that the problems that arise when one sends a summary assessment to a cost judge who hasn't dealt with the matter are shown here, because this was a case where there had been a split cost order, so there's liability for costs of two different periods. There needs to be consideration from the parties of how to split the work, without trying to suggest that it's too technical, but there may well be items which would need to be apportioned or split in certain ways. And what the judge did was impose a very strict timescale. And essentially what the appellant says is, if it's permissible to send to a cost judge for a summary assessment, then the cost judge would inevitably have to have some sort of directions hearing, because the cost judge could not have the parties turn up on the day with their N260s and be expected to summarily assess the costs. I mean, that's the reason why I say the rules don't allow it, don't permit it. The cost judge would have to have significant extra or additional papers in order to undertake the process. And what the directions did was essentially to adopt a strict 21-day timescale, which was manifestly unreasonable, I say. It was unreasonable because on the facts, the solicitor, it covered the Easter break and the solicitor was away. But it's a fundamental point in my submission that if I'm wrong about the ability to send a summary assessment to the cost judge, then it should be a matter for the cost judge in terms of timescales, etc.
What actually happened? Did the parties comply with it? Was there a stay?
There was a stay. The senior cost judge stayed the matter, as I understand it. Yes.
Well, perhaps it doesn't really matter now. I mean, the 28th of April 2022 has come and gone. If we allowed the appeal and ordered detailed assessment by a cost judge, then the timetables would be set by the cost judge or somebody in the costs office. If we said no, the summary assessment should proceed, we would whether we would have the power to impose a timetable, or whether that would be down to the costs office. But 28th of April has long gone.
That's why I don't. This isn't front and centre of my submission.
No.
But it is perhaps, if I'm wrong about the main points, there is potentially an important point here, that if it is going to go to the cost judge, then it's the cost judge in my submission who should be dealing with directions, because on a practical basis, a cost judge would have great difficulty, or any judge in fact would have great difficulty summarily assessing costs that he knows nothing about, or she knows nothing about, without some directions as to what should be lodged. So it's really a question of whether the judge who sends it for summary assessment should make the directions, or whether the cost judge should.
Well, let's assume you're wrong on the main appeal, and that it was perfectly competent for Mr. Justice Linden to send it off for summary assessment. Summary assessment, we know, is a procedure which happens day in, day out, with people lodging N260s before the hearing, and that is intended, as you said right at the outset, to be quite a brief statement of costs you've incurred. All you need to do on this order is to, I think it applies to both parties, divide your N260s that have already been filed into pre and post whatever the date is. And speaking for myself, I don't, for the life of me, why, if the judge can direct summary assessment at all, he can't direct that the steps be taken to lodge the N260s. And 3 weeks seems to me perfectly ample to split a bill into two parts.
Well, there were issues as to Easter break and vacation time, but I accept the point, my lord. But there is part of that point is really relates back to my first point, that my lord.
I understand that, but at this stage of the argument, you've lost that.
If I've lost that, then the parties are attending the senior courts cost office with their 4-page N260s, and the judge will take a view, and that's what he'll have to do. But I don't wish to push the point further. Unless there is anything I can assist with, those are my suggestions.
Thank you very much.
Thank you.
Mr. Jones.
My lord, can we go back a few stages, please, to consider a little bit more carefully and perhaps a little bit more detail the difficulties which the learned judge had with this hearing? I've taken your lordships to the transcript, and I've explained, I hope as clearly as I can, that at the hearing it was accepted that there should be a summary assessment by a master of the senior courts costs office, except that that master should not be Master Brown being the learned judge who had conducted the original detailed assessment. So it comes as some surprise to us that, having made that concession at the hearing, we now come to this court and are told that the appellant is cross with the ultimate decision which was made, which was that there should be a summary assessment by a judge, by master of the senior courts costs office. That's the starting point. Then one needs to look at the context by which this case came before Mr. Justice Linden. The original bill, my lords, was put at approximately £88,000, and it was reduced by Master Brown at a detailed assessment to approximately £23,000, if I remember rightly. Your lordships will forgive me if I've got the figures wrong, but the reduction was some 71%. There were three principal reasons, my lords and my lady, as to for those reductions. The first, and I say the most serious, was a breach of the indemnity principle by the solicitors, because it was not until the hearing before Master Brown that it became apparent to us that the original retainer letter had stated that a particular fee earner would be charged at £120 an hour, but the bill, which had been certified by an officer of the court, had claimed £175 an hour. That was a most serious breach of the indemnity principle, the cases Bailey and IBC vehicles. That was the first reason why the bill was reduced by so much. The second reason was because the solicitor thought it appropriate to include in the bill vast swathes of costs that were incurred in the upper tribunal and which were not encompassed by the scope of the costs order that led to the original detailed assessment. Yet that same solicitor had certified the bill as being accurate and complete in all respects. That was also a most serious breach of professional obligations. The third reason for the considerable reduction was because the solicitors thought it appropriate that time incurred in supervising a solicitor advocate, i.e. a solicitor with high rights of audience, by another solicitor was something that could be recovered on a standard basis assessment. And the learned judge, the learned master in my submission, broadly but not exclusively decided that those costs at least should be reduced by a substantial amount. He certainly, he did allow some costs, if I remember correctly. I think I did the assessment. So the result of all of that is that we have a number of serious breaches of professional obligations, a reduction of 71%. We then have an appeal on two bases. The basis that was really pursued was the cost of the detailed assessment, because Master Brown made no order as to the costs. And that was appealed, and that was the part of the appeal that was compromised by the Part 36 offer. The second part of the appeal, which was not abandoned until I think it was a letter of the 9th of December 2021.
I'm sorry, could we go back? You're saying they were really pursuing the no order as to costs in relation to the detailed assessment.
That's right, Melanie.
Yeah, and then you went, and that was,
was
compromised by the Part 36.
By the Part 36 offer.
Excuse my ignorance. What's the practice of the cost judges exercising the detailed assessment jurisdiction over the costs of detailed assessment itself? I thought there was some rule of thumb that if your bill was knocked down by a certain amount, you didn't get the cost. Is that...
No, my lord, no. I wish it were as straightforward and simple as that, if I may say so. The position is that it's CPR Parts 4720. If I may just have a moment.
It probably doesn't matter for the purposes of appeal, but just as a...
No, well, I can explain this relatively quickly, my lord. Your lordship will see 4720, it's page 1674 in the current edition of the White Book. 4720, the receiving party is entitled to the costs of the detailed assessment proceedings except, and B, the court makes some other order. So there's a presumption that the receiving party will get the costs of the detailed assessment unless the court makes a different order. A bit further down, paragraph 3, in deciding whether to make some other order, the court must have regard to all the circumstances, including conduct, the amount, if any, by which the bill of costs has been reduced, and whether it was reasonable for a party to claim the cost of a particular item. Or to
and that it also incorporates Part 36, and presumably the usual practice, if you think a bill has been inflated, is to make a much lower Part 36 offer and hope you beat it.
Well, there's that, yes. But the submission I'm pretty sure I recall making to Master Brown was, you've just reduced this bill by 71%.
Yeah.
Look at the rules.
If there's ever a case where...
Absolutely. And he
accepted that.
He agreed with me on that. Yeah. And he made no orders to cost. So that was
appealed. And you compromised that.
Yes.
Yes.
We made a
by means of a Part 36 offer which was accepted.
Correct.
You compromised both the appeal against the reduction.
No.
And
No.
Well, there was never an appeal against the
Yes,
reduction.
there was, my lord, there was. The appellant put his case in there were two grounds for appeal essentially. One was the cost of the detailed assessment, which we've just discussed.
Yes.
The whole of the detailed assessment was appealed. Mr. Justice Martin Spencer, I think, was the judge that gave permission to appeal. And what he said was, I'm giving you permission on the costs point. Because you've got permission on that, I'll give you permission on the rest, but it's pretty weak. And Mr. Justice Linden referred to that in his approved judgment. He said, well, I might not have granted permission, but that doesn't matter. So permission
In the end, it wasn't pursued, it was abandoned.
Eventually. It wasn't abandoned until, I think, the 9th of December 2021. And your Lordships may recall in the approved judgment there was some explanation by Mr. Justice Linden that, unfortunately, it hadn't been communicated to me that the appeal, that part had been abandoned at a time when it ought to have been communicated to me, which is why, unfortunately, I wrote certain correspondence to the judge, which I wouldn't have written if I'd known the true position. But anyway, it was then compromised. It was then abandoned. So we come to the hearing before Mr. Justice Linden with a Part 36 offer in relation to the costs of the appeal, which compromises it, although there is some argument from the appellant about that, which Mr. Justice Linden had to resolve. And we have the abandonment of the rest of the appeal. We have an argument on the part of the appellant that he should not pay the costs of the rest of the appeal, which Mr. Justice Linden had to deal with. Which is why he made us a cost order in favour of both parties. And then he has to decide, how am I going to deal with this? I'm faced with two cost schedules, summary assessment cost schedules, provided by the parties, which don't help me through no fault of their own, because I've made a different order. Pause there, if I may. If Mr. Amesier was able to produce a cost schedule for summary assessment before the hearing, before Mr. Justice Linden, why was it so difficult to produce another one within a relatively short period of time? That doesn't make sense to me at all. He'd already produced a cost schedule for summary assessment for that hearing. He'd filed it and lodged it before the hearing. Why is it so difficult to amend?
He has to take that. He has to split out. He has to split it, I think, twice. First, temporarily, he only gets costs up to a certain point, but also, I think he only gets the costs of the first part of the appeal.
Yes.
He doesn't get the costs of the balance of the appeal.
No.
You get those.
No.
Yes.
So why is it so difficult? If you can do it before this hearing, why is it so difficult to do it to correct it afterwards? We did it. We had no difficulty. We lodged our cost schedules in accordance with Mr. Justice Linden's order. Why is it so difficult?
Yeah.
So I don't get that, if I may say so, my lords. And I came up with the draft order, which put it back to the Senior Courts Cost Office. And as I've explained, the only issue, as far as I understood it at that hearing, from Mr. Amesier was his objection to it going back to Master Brown.
Yes. Yep.
And that's what the judge... So, why is it then, in my submission, objectionable in these circumstances? This is a relatively straightforward appeal to a High Court judge about two issues. It's not complicated. It's not difficult. What is the objection to the learned judge using the rules and the overriding objective to come up with a solution which uses the court time, in his view, in the best possible way? And looking at this in the round, I say that the discretionary decision that he made must be looked at in the general context. Is it really a good idea for these parties to have to be embroiled in two detailed assessments when one of them has breached his professional obligations big time already? How much more by way of costs do your lordships consider ought to be expended in this relatively small exercise? Because that was the question which I asked myself at the time that I was formulating the draft order, which was put by those who instruct me to our opponents, and which was put before Mr. Justice Linden, and which I thought at the start of the hearing the only issue was Master Brown or somebody else. So that's the context
Sorry, and also, therefore, before Mr. Justice Linden, there were no submissions about the nature of summary assessment and detailed assessment
No.
and all the rest of it.
There didn't need to be because it was by consent. And
That does raise this question. I mean, it's perfectly obvious the case you're facing is not that this was a discretionary decision that was the wrong discretionary decision, but that there was no discretion at all.
well, can I deal with
Yes, no, you will do that. No, the question I want to ask you is this. Suppose that it's right that the rules do not, on their true construction, allow for a judge to remit a case for summary assessment to a cost judge. But, nevertheless, the parties consented to it. What is then the position? Is that something which can be appealed because the court has no jurisdiction to do it, or is it something that the parties are stuck with because they agreed to it?
The latter, my lord. This is the bewildering part of this appeal, as far as we're concerned. Everything, we thought this was clear. That you've seen from the transcript, Mr. Justice Linden was saying to Mr. Amizier, "Tell me what the issues are. I need to know what the issues are, and then I'll hear submissions." In my submission, once the parties came to that agreement, it was perfectly legitimate, using the overriding objective, using, frankly, much more than common sense, to make directions, which I accept would now need to be revisited because of the passage of time. But I say there is nothing objectionable at all to what Mr. Justice Linden did in the particular circumstances of this case. That the parties had said, "Yeah, let's have a summary before a master." And I say the only issue is Master Brown, and the judge ordered. I say there is no difficulty with that. May I deal with my lord's point about discretion, and we come to 44.6, please. I do rely on the word "may" in the second line. Where the court orders a party to pay costs to another party other than fixed costs, it may either do those two things. I do rely on that because if it was intended to be prescriptive, it would say must, and it doesn't.
But I understood it. The real point you're facing is not so much the wording of 44.6, but the definition of summary assessment, which says it's assessment by the same judge.
Well, I accept that, but I'm looking at this rule, and it says may, it does not say must. It does, in my submission, it gives complete discretion to a learned judge in the right circumstances, because I do accept the premise that there will be cases where it would not have been appropriate for the judge to have done what Mr. Justice Linden did. I accept that. I'm not saying that there's a hard and fast rule that he should do it. I'm saying that it's completely discretionary. And your lordships and my lady, one of the tasks for you is to ask yourselves, was the decision that Mr. Justice Linden made outside the range of reasonable discretion? In other words, this was a discretionary decision. It's not good enough for your lordships simply to say, well, we would have made a different order. Your lordships are only entitled, in my submission, to interfere with it if it is outside the realms of reasonable discretion, such that no reasonable judge would have made it.
Well, another way of putting the difficulty we face, speaking for myself, if the judge had power to make such an order, I don't see what was wrong with it.
Yes.
The problem is whether he had a power.
Yes.
And although you've focused on the use of the word may in 44.6.1, the highest hurdle you've got to jump is the definition of summary assessment in 44.1.
Yes. Which I accept, of course, what it says. But in my submission, again, if you look at the overriding objective, the need to interpret the rules in such a way that justice is done proportionately and at proportionate cost. As I said earlier, probably a little too loudly, if I may say so. How much cost do you want to expend on this? If we have to go down the detailed assessment route, let's just look at what has to be done. Both sides have to draw up a formal bill. Then both sides have to produce points of dispute to each bill. Both sides would be entitled, and they usually do, produce replies. Replies are optional, but in most cases they are done. There is then a request for, in this case, provisional assessment, because I hope nobody is suggesting that any of these costs could possibly exceed £75,000. Although
Do we know what the N260s were for the whole thing?
We do. Mine, I think, were less than 10, approximately 10,000. I think Mr. Amizio's was a little higher, possibly 13 off the top of my head. I don't think anybody is suggesting that they would be anywhere near £75,000, but I do draw attention to what I said earlier. We had a bill from Mr. Amizio, which was pitched at 80, whatever it was, and that was reduced to 23. We've had the form on that before. So we then have a request for provisional assessment. It goes in front of either a cost officer or a master or a deputy master. It's dealt with hopefully on paper, although the court has power to direct that there should be that it comes out of provisional assessment, and that does happen. Relatively small bills can be put in for detailed assessment, and they are put in for detailed assessment. So assuming that doesn't happen, the decision is then sent to the parties. They have 21 days to decide whether to accept it. If they do, that's the end of it. If they don't, there is then an oral hearing. Do we really want all of that arising out of this one appeal? That was what was going through my mind when I drafted the order. Now, I accept that I'm going off the point a bit about the definition of summary assessment, but whatever the definition is, whatever it actually means, I do say that it doesn't actually matter, because the court has got, in my submission, sufficient discretionary power contained in the overriding objective and in 3.1M to say, up with this, I'm going to have a different scenario on this occasion, particularly when there's been consent.
And so I wanted to take you back to this issue of discretion and where you get the discretion from. And you've just said that you're relying, in effect, on the overriding objective and also 3.12M, which is doing all other steps which may be necessary, etc., etc.
It's the catch-all. I accept it's the catch-all. I haven't got much else to say argument, but it is important.
Yeah,
but it's introduced by the words "except where the rules otherwise provide." Yeah. So that's the question. Do the rules otherwise provide? I mean that.
Well, it's circular, if I may say so, because you can go back to the overriding objective and say, well, they do provide.
Well, and that's what I wanted just to get to the bottom of, so that I'm sure about your submission. I think earlier you were relying on may in 44.61, and that is may either do A or B. And I'm not, that's just how the words stand. I'm not trying to make any point in relation to them. But nevertheless, you say that may enables the judge in A to be flexible. That's your first point. You go as far as that?
Yes.
I just want to be sure.
The whole thing is discretionary. From start to finish is most.
So may imports a discretion throughout.
Yes.
Whether you're in A or B, that the may infects it. Yes. That's your first point. Yes. Then you're saying, and you must read these rules in relation to the overriding objective, look at sledgehammers and nuts, and etc. And then you're saying also 3.12M assists me here. Those are those are the limbs.
My lady has put it perfectly well, and bearing in mind that I don't wish to be flippant when I say this, it's not as if Mr. Justice Linden was going to send this off to the property chamber of the first tier tribunal. He was sending it off to the specialist court. The clue's in the title, the Senior Courts Costs Office. That's what it does. So when you look at everything in the round, all the surrounding circumstances, the history between the parties, the reason why we were there. And you look at what Mr. Justice Linden described in his judgment as the entangling by the appellant of the two aspects of the appeal, which he described as unhelpful. If I may say so, that was a charitable way of describing it. It was extremely unhelpful. It was not conducive to trying to sort things out. What was he to do? Was it really right for him to commit the parties to two detailed assessments?
I think the submission you're facing is the only choice he had was between sending it for detailed assessment or if he do it himself, which raises a question. If we think the appellant is right, I know this is quite a long way down the line, and you say the appellant's wrong, but if the appellant were right, what order should we make? Should we send it back to Mr. Justice Linden to do the summary assessment himself, or should we send it back for detailed assessment?
Well, that is a difficult question, and you're entitled to ask it of me. I would plump for sending it back to Mr. Justice Linden, because with the greatest, if my learned friend is right about that, I appreciate that Mr. Justice Linden's mind will have been focused on a bunch of other things other than this, but
if those are the only choices,
it's the lesser of two
better.
evils, is it not? Regrettably, your lordships would have to ask him to deal with the matter himself, rather than Master Gordon Seiko, which is the judge who has it in the Senior Court's Cost Office. But I don't.
I mean, I think your point is that's the stark effect of the case you're facing. That we don't have a choice to do what you say is the sensible thing. We can only do one of two unsensible things.
Well, I find it quite difficult, my lord, to accept, or I won't accept that the court can't do what's sensible.
No, but that's what's been argued.
Yeah, but it's an unpalatable, disproportionate, costly, frankly unacceptable result.
It's a straitjacket.
Which, and I don't accept as a straitjacket.
Yeah.
I think the court can act in the way that it did. And as I say, when I formulated the draft order, I was anticipating that I was thinking about what's the best use of court time here, and do I trouble a busy High Court judge, or do I trouble a busy master of the Senior Court's Cost Office?
All right, Mr. Judge. I think you've given quite a lot of evidence about what was in your mind when you drafted the order. Of course, you didn't. It's not suggested that when you drafted the order, you were trying to get the judge to make something which he had no power to do. But what you're saying is, you say there is, he did have power to do it because of the overriding objective. But if the truth is that the choice was only between summary assessment by Mr. Justice Linden or detailed assessment by cost judge Gordon Saker or anybody else, then you submit on proportionality grounds it should be sent back to Mr. Justice Linden.
Yes.
All right.
That would be. I think that would be consistent with the finding that your lordships would then make, which would be against me, but it would be consistent rather than having a detailed assessment for these sorts of amounts of money in my submission is way disproportionate in these circumstances. This was a hearing that lasted a morning, if I remember rightly. I don't think it was any long. I don't think it went into the afternoon. I can't remember, but
it doesn't look like a very long transcript, although we've only got half of it.
No, but I'm my recollection. Mr. Remizio may assist us. My recollection is that it was done.
There or thereabouts. Part of the day.
Well, it's just an argument about the costs of an appeal, which is not being pursued substantively. I mean, it really shouldn't take very long.
Not difficult. So, in essence, my lords, those are my submissions. I mean, unless I can assist your lordships any further, I've been relatively brief, and I do apologise to my little friend for hijacking part of his submissions, but I hope what I said was.
You've both been very helpful, and it's sometimes useful to the court to have a bit of a debate. But thank you very much.
Could I just say, so that I'm certain, I'm sorry to interrupt you, in relation to the second round of appeal, I think we have your submissions in relation to that, which is what was wrong. What was wrong with that?
Reasonable
Yeah,
case
thank
management
you.
decisions which are not susceptible to appeal on the grounds of discretion by this court in my submission. Yes.
Thank you.
Thank you very much.
Yes, Mr. Dunn.
My lords, my ladies, I will be brief, I hope, in responses. My learned friend seeks to set out the background and the reasons behind what led to the order, but of course, while that is all very interesting, it is not what is being asked of this court. And what is being asked of this court is there a discretion? And if there isn't, then the order was impermissible and it was wrong.
Even if made by consent?
Well, the consent argument is an interesting argument because it's certainly not accepted by those who instruct me that there was consent that there should be a summary assessment. And it isn't raised, it's no part and I'm rereading the respondent's notice and the respondent's skeleton argument. It's no part of their argument that this was an order by consent or this was consensual and therefore this isn't really a question at all about whether the judge had the power. This is a question about whether the parties can opt out of what the rules say, which is a very different argument. And it's an argument that's been looked at in the context of fixed costs and various other things before by this court. But it's not the point that's being argued here. The argument was, there was arguments about whether there should be a summary assessment from Cost Judge Brown, and obviously there was an objection to that. But the transcript itself, and this is part of the problem with the transcript doesn't have any of the submissions from the solicitor advocate who attended. So it isn't a question of whether one can consent out of the rules. It's a question of whether the judge was entitled to make the order that he made. We don't accept that we agreed or consented in any event. But it's not, I mean, my learned friend used the word bewildering about this appeal. It's not bewildering at all when one considers the implications beyond, and of course this court is concerned with the implications beyond this particular case. It's not bewildering. It's important in my submission that parties are not on the subject of rough justice unless it is prescribed by the rules in certain and particular circumstances. And the respondent has never at any time when this appeal has been lodged said, right, well, we accept that the order was impermissible, let's talk about what we do thereafter. The argument is, the arguments between the parties is, the respondent says it's discretionary, and we say it isn't. And that ultimately is the beginning and the end of it. What happened at the assessment and everything before really, I would submit, is irrelevant. My learned friend makes a point about how a detailed assessment would be disproportionate. And again, that is a secondary point. That's a question of what this court, if I were to succeed, what this court would do in terms of an order. The only point I would make is that a detailed assessment of costs of this level would be a provisional assessment in the first instance, limited by the rules to £1,500 costs of that assessment.
And is it right that for provisional assessment, you go through the process, you have to produce a detailed line-by-line bill, and you put in points of objection and points of reply?
Yes.
So you do all that process, but
You can only get
1,500, which presumably rather mitigates your desire to take every point available.
Well, it should do. And
It's plus VAT and the court fee.
yes, plus VAT and the court fee, my learned friend is quite right. But what it does mean is that there is already inbuilt in the detailed assessment process a proportionate process for dealing with cases of this nature. So,
More proportionate process. I mean, there's no doubt that detailed assessment is a more expensive, time-consuming and complicated process than a summary assessment. It's meant to be.
of course, and well, quite so. It is meant to be, and it has to be. That's my general point. But it isn't true to say that detailed assessment means that lots of costs and summary assessment doesn't. I mean, one could suggest perhaps that a £1,500 cap plus VAT, if there was a morning before Mr. Justice Linden summary assessment, one might end up spending more than £1,500 plus VAT on such a hearing. But it's not an either or in that situation. But in any event, that's a secondary point because I would have to win the appeal for that to become important. So, and my final point is simply this, that it's not unpalatable to consider the rules as they plainly purport to state. It is in fact important so that parties are able to have a just assessment of their fees for both sides, whoever's paying, whoever is receiving their costs. And so in my submission, the discretion simply isn't there and the order was impermissible. And unless I can assist any further, those are my submissions.
Thank you both very much. We'll rise to discuss the matter. We may or may not be able to give you a decision today. We will almost certainly reserve our reasoned judgment in any event.
Just let me know the recording will stay on.
Yes.
You know, the hearing is this stream.
Yes.
It's online.
Yes.
So if I want to see it, where do I see it?
On YouTube.
Yes.
Do you want me to write it for you?
Please.
So on YouTube, search up Court of Appeal. 75.
Now.
Yeah. Are they going back?
Yes.
Okay, let me-
Yes, we should probably
Could you let them know I'm
Yes,
just gonna go
it's empty at the moment.
Oh, right, okay. Would you like to play a
Yes, please.
Yes, yes.
I'll let them back in.
Yeah, yes, I can
Yeah.
wait. I actually know what it's supposed to
Yeah,
say.
yeah. Thank you. Is everyone ready? What's rise?
We have decided that the appeal will be allowed and the case remitted to Mr. Justice Linden for him to carry out a summary assessment. We'll give our reasons for that as soon as we can. What we would like to do now is hear argument as to what order we should make as to the costs of this appeal.
Well, the appellant would seek their costs of the appeal on the standard basis, either to be summarily assessed on paper by this court at the point, because obviously once the reserved reasons are sent, we will be in touch with the court as to corrections, etc. And at that stage, parties can put in their own 260s. The alternative, and this is obviously opposite after we've just heard these arguments, but the alternative is a detailed assessment. We wouldn't seek details.
No.
Do we
Summary
not have
assessment.
N260s already?
We don't. We were assuming that we would have reserved a reserved judgment. So I do apologise for that. We don't, but we can, if it can be done, if it's necessary, we can get those.
If we make an order for costs, then obviously it should be to be summarily assessed by us on the papers, and both schedules should be submitted. On the other hand, Mr. Joseph may be about to say that since this point wasn't taken before the judge, there shouldn't be any orders to costs.
Yes.
So would you deal with that in anticipation?
I will. I will. And Councillor, nothing if not predictable. It's the sort of thing I would have said if I was him. I simply say this, that it is right that in the cut and thrust, although it's difficult because I wasn't there, but from what I can see from the transcript, it's right. This wasn't dealt with in the way it's been before this court, and I fully accept that. Ultimately, it was a question that was raised in the respondent's skeleton argument. There was a suggestion that once the transcript was in hand, they may revise their respondent's notice, presumably to argue that very point. To say it wasn't raised as a point, it wasn't raised below, etc. Realistically, considering the standard criteria in terms of the fact that it's a pure point of law and there was no prejudice because the parties have known throughout this appeal what is being argued, it wouldn't have gone very far had they done so. But the remedy in these circumstances, I say, for the respondent is simple. When the appeal is brought, they can simply say, on analysis, yes, you're right, the rules don't provide for this, and therefore the appeal doesn't need to go forward. What the respondent has done, which is their right to do, is to challenge the appeal on a fundamental basis, which is to say that the rules simply do not say what we, the appellants, say they do, and to argue essentially that there is a general discretion which would have a huge implication for the entirety of civil proceedings, because it would mean that cost judges would be sent summary assessments to do. So they've chosen, the respondent has chosen to fight this appeal knowing what the arguments are. They've chosen to fight it on the basis that the rules do not say what we have always argued that they do, and on that basis they should pay the costs of the appeal. As I say, at the outset they could have said the appeal is accepted, withdrawn, and then there would have been a good argument at that stage that any cost that we had incurred shouldn't be ordered. But if one takes the point, fights the appeal all the way, I do say that should mean the costs of the appeal are payable. Thank you.
Yes, Mr. Jason.
My Lords, very briefly, I do say that the right order in all the circumstances is no order as to costs of this appeal. I don't understand why a cost schedule hasn't been produced. We produced one.
I have yours.
Yes, I don't understand why it's not been produced. We could have dealt with it today if your Lordships were minded to make an order against my client, but we can't because there isn't one. But ostensibly, it does seem to me, of course, without having the benefit of your Lordship's reasons, it does seem to me that there's a lot that was not run below that ought to have been run below, and is now being run today, and which your Lordships and my lady have decided will be successful in whatever way your judgment says. But in the scheme of things, I accept what the rules say, that costs usually follow the event, but the court has a discretion to make a different order, and in my submission in these circumstances, that's what should happen.
Right, thank you both. That's very helpful. We won't give our decision on the costs point today, but we wanted to have your submissions so that we don't have endless rounds of written submissions. And both put it very helpfully. So the formal position is we reserve our judgment. We will give the reasons for our substantive decision and give our actual decision on the cost of the appeal as soon as we can. The document will be sent out in draft, subject to the usual 2 points which I'm required to state at the end of every appeal. There you both know well. Firstly, that the draft is sent out not for re-argument of the case, but only for correction of typos and obvious factual errors. And secondly, that the draft is subject to the restrictions on publication identified by the Master of the Rolls in the Counsel General for Wales case. Whether the wider world will be interested in our reasons for this decision, I don't know, but the rule still applies.
My Lord, may I just, I should have pointed out before, but the appellant already has a cost order in respect of the respondent's notice, which was filed late, which we...
Oh, thank you. Yes. Well, that obviously stands.
Yes, I was just wanting to make that.
Yes. Thank you very much.